Court does call the case of the People versus Jenny Lou.
Ashley Lonnie for the people.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Lou, Judge, who I believe is present here via Zoom.
Yes, she is. Ms. Lou, can you state your name, please?
Yes, sir. Jenny Lou.
Thank you.
Your Honor, I believe we have a resolution in this matter. I have had a chance to speak with Ms. Lou. I believe upon a plea to attempted resisting and obstructing in case 23 F10628, that the felony in that matter will be dismissed and the matter 24 F10014 FY will be dismissed in its entirety.
Correct. The plea sheet that I have indicates she'd be pleading no contest to an added count two of attempted resisting and obstructing a police officer, 1 year offense.
That is
On her successful plea, count one in that case would be dismissed, as well as the case ending in 014.
Yes, Your Honor, and I have had a chance to meet with her, and I did go over her rights. She understands those. She is a U.S. citizen. There are no PDA issues. Is that correct, Ms. Lou?
I don't need to know that.
Oh, I'm sorry,
Yeah.
Judge.
All right.
That is a correct recitation of the plea agreement, Your Honor.
Okay, very good. Ma'am, if you could please raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yeah.
All right, state your name again, please.
Jenny Lou.
All right, you can put your hand down. Ms. Lewis, it's court's understanding that in the case ending in 0628, that you're going to be pleading to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. Do you understand that?
Yes.
All right. Do you understand what a no contest plea is?
Yes.
All right. Two things about it I have to make sure that you understand. The first thing you need to understand is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Mr. Gaddy, the basis for the no contest plea.
I'm sorry, Judge. Potential civil liability.
Ms. Lou, to the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
Did you want to plead no contest, Ms. Lou, like we discussed?
I thought that's what it was.
Well, no contest is,
So am I
But you're
saying no
not
contest?
if that's how you want to plead, yes.
Okay, yes, sir. Can I say no contest?
All right, let's do. You want to do over. All right. So to that charge, how do you
Please.
plead?
No contest.
There you go. Now you understand that by
Apologies.
pleading no contest, you will not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
You are not. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
Court has been provided and has reviewed Michigan Department of State Police report for their case number 1957-23. Any objections to the court having reviewed that report?
No, Your Honor.
None from defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Judge.
Court will accept the defendant's plea to count two in the case ending in 628, and count one in that case is dismissed, as well as the case ending in 014. That case is dismissed. This is a victim's rights case, so.
It is, Your Honor.
Pre-sentence investigation and report is ordered at 14A probation. Sentencing in this matter will be
June 11th at 9 a.m.
June 11th, 2025, 9 a.m. before me. Bond will continue in this matter. Okay,
Thank you, Your Honor.
thank you, Ms. Lou.
Thank you, Your Honor.
Okay, so on June 11th, what's gonna happen? I'm coming back.
Yes, you'll come back and I'll impose sentence. I can't do it today because the victim has to be contacted in the case. And so otherwise I would sentence you today, but yeah, you'll come back on the 11th.
All right, Your Honor, thank you.
All right, thank you.
I'll talk to you before then, Ms. Lou.
Okay.
Court calls the case of the people versus Jacob Dorston.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Dorston, who is making his way to the podium, Your Honor.
Your name, sir?
Jacob Dorston.
All right, what are we doing on this case?
Your Honor, Mr. Dorston would like to set this matter for preliminary examination. We have had discussions with the people, but he'd like to set this matter. Discovery is complete to the best of our knowledge.
So he's not requesting the adjournment on the,
Oh, no, Your Honor, that's my fault.
well, no, that was from last time. I'm sorry.
Oh,
All right. So all discovery is complete.
yes, Judge.
People have their witnesses available the 27th.
I believe so.
Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Freshour. Continue.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Kennedy Braddock.
David I. Goldstein appearing on behalf of the defendant.
Kennedy Braddock.
All right, thank you.
That wasn't me.
I know.
This time.
This time. All right.
Your Honor, we've executed a waiver form. We're going to be waiving exam seeking resolution in circuit court.
Is that correct, ma'am?
Yeah.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yeah.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of information in this matter. My client waives further reading, stands mute, asks that a not guilty plea be entered.
Defendant having waived former reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
July 9th at 1:30 p.m. with Judge Conlon.
July 9th, 2025, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue. Court does call the case of the people versus Anthony Flanagan.
Joseph been calling up the people.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Anthony Flanagan.
Thank you. What are we doing?
Your Honor, as the court is well aware, there was a competency evaluation done in this matter. We are now going to be asking for an evaluation on criminal responsibility, but we'll do that in circuit court. So we're going to waive exam.
Okay. All right. Is that correct, sir, that you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
All right. You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
We do, Your Honor.
Your Honor, we
Preliminary
acknowledge,
examination having been waived, defendant is bound over to circuit court on counts 1 through 5 with 6 following. Go ahead, Mr. Motion.
Your Honor, we acknowledge receipt of the information in this matter. We waive its further reading. My client stands mute, asks that a not guilty plea be entered.
Defendant having waived formal reading, standing mute to all 6 counts. Court will enter a not guilty plea. Pre-trial will be set for
June 3rd at 1:30 p.m. with Judge Conlon.
June 3rd, 2025, 1:30, Judge Compton.
You're all set.
Bond continued. Thank you. Court does call the case, people versus Corey Craig.
Alexander, on behalf.
David I. Goldstein, appearing on behalf of the defendant.
Your name, sir?
Corey Craig.
All right. What are we doing?
Your Honor, I was prepared to ask the court for an exam date, but I was informed this morning when I got here that there may be some media that has not been provided as of yet.
And that's correct, Your Honor. I did put in a request for media discovery yesterday as well for the 911 call. I have not received that.
All right. And we'll say would you be available on 29th?
I'm looking at the 27th for some reason. Yes, Your Honor.
All right. Probable cause conference will be adjourned May 29th, 2025, 9 a.m. Bond will continue.
Thank you.
Court does call the case of the People versus Haley Gregg. Oh, boy.
Good morning, Your Honor. Great to see you. Christina Costantino appearing with and on behalf of Haley Gregg. Gregg?
You're over there. Your name is?
Haley Gregg.
Judge, this is a date and time set for a PCC, and we have reached a resolution in this matter. I do have a plea agreement if I could present that to the court. Thank you.
Okay, so how am I going to accomplish this?
Do you mean because it's a no contest plea? Or?
Yeah. And I don't have a report.
I do have a clean copy of the report if I could also present that to the
So
court.
I'm supposed to read that now.
I know, Judge, I apologize.
Okay, the plea agreement indicates that she's going to be pleading no contest to the charge. The maximum penalties on here either.
That would be my fault.
Judge, if I could, the maximum possible penalty is 1 year.
Maximum fine.
That one's a good question, Judge.
It's $4,000.
That it was. 1,000 on the attempt.
I believe it should be 500.
Yep, we're rolling along in this.
Sorry, Judge, I had to come along
Reaching home and
and mess
I will
everything
blame
up.
both of them all day for this.
So,
Not you.
sorry.
You're good. Is it not your fault at all?
No, it's not.
I am looking at the attorneys that don't seem to be ready.
Very sorry, Judge, very sorry.
What's the maximum? Well, hang on, folks. The maximum penalty on this is going to be, well, give me the max on unlawful use and just cut it in half.
My understanding, the max on unlawful use is 1,500.
It's
However,
1,500.
It says if the case is a first offense, the court may reduce the punishment for imprisonment or the fine of not more than $500. So the maximum would be 1,500. The court could, of course.
On
do
the
more.
principal charge, it would be
Yes.
1,500, which means on this attempt, it's 750.
That would be
All right.
my understanding. My math is not great, but it seems right.
Has she signed an advice of rights will?
Judge, I'm sorry.
But let's see. We called one case of Constantino's and I could have done like 8 cases.
I know, Judge, I'm so sorry.
No, it's okay.
You decide here.
I
It's
have
hard to get the
I have no
signature when they're in
waiting.
custody.
problem waiting. I don't think the rest of these people have that same feeling.
I understand. I apologize to all of my colleagues.
All right. Are we finally ready?
I think so, Judge.
Yeah, let's see. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Haley Gregg.
All right. Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of attempted unlawful use of a motor vehicle. That is a misdemeanor punishable by up to 1 year incarceration and a $750 fine plus court costs. You understand that?
Yes, I do.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right, 2 things about it. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. Hear me?
Yeah, I can hear everybody else.
Okay. You understand that it means that you're not willing or wanting to contest this charge.
Yes, I do.
All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, I do. Your Honor.
All right. Now understand, and the basis for the no contest plea.
Potential civil liability.
All right. Understanding all of that, do you still wish to plead no contest?
Yes, I do. Your Honor.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, I am.
All right. You signed an advice of rights form, is that correct? A question regarding any of those rights? You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up, pleading no contest, you're giving up those rights as well as all the rights on that form.
Yeah.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes.
of your own free will? And because you believe that you are indeed guilty, or I won't ask you that, never mind. Court has been provided Ann Arbor Police Department report for their case number 25-17-355. Any objection to the court reviewing that report to form the factual basis?
No, Your Honor.
Based upon the review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt to the defense counsel. Have I complied with the court?
You have, Judge.
Yes, sir.
Court will accept the defendant's plea of no contest. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing in this matter will be
June 6th at 10 a.m. with Judge Perry.
June 6, 2025, 10 a.m. before Judge Perry.
Thank you, Your Honor.
Thank you.
Would the court allow me to address Ms. Gregg's bond?
Sure, let's spend all day on this. Go ahead.
Sorry, Judge. Your Honor, her bond is currently $5,000 with a 10% provision. She's unable to post that bond. That bond was set in mind with this charge being a felony. She has now pled to a 1-year misdemeanor. She spent the last 50 days incarcerated. Should she be released, she does have stable housing. That would be in Ypsilanti with a friend. She does also have employment lined up as well, should she be released. We would ask if the court would consider a personal bond. She's also been in touch with Community Mental Health, and she will be working with them upon release.
Response.
Mental health, we would not have objection to the lowering of the bond. Since it's in the district.
Okay, I will for bond to a $5,000 personal recognizance bond. Defendant, and with the condition to maintain contact and communication with Community Mental Health. Okay,
Thank you very much, Judge.
you're good.
Oh, yeah,
All right. Follow through on everything.
I will.
You hear me?
Yes, I will.
All right,
Thank
thank
you.
you.
Thank you, Judge.
Court does call the case of the people versus Antoine Pitts. Speak French again. Antoine Pitts? Really? So there's a prosecutor on this too? What? Is this your case?
Well, the two of us are looking at each other like, who, what? David I. Goldstein appearing on behalf of the defendant. I didn't have this on my calendar for some reason, Judge. Apparently neither did she.
All right.
Your Honor, I received an email from Mr. Pitts last night. Apparently he's having a medical problem. He did send me a medical letter indicating he's been ordered for bed rest and oxygen. I'm trying to find it so I can show it to the prosecutor in the court.
Well, when did that happen? Because I issued a bench warrant for him without bond because he has not done anything at community corrections.
That was within the last couple of days, Your Honor.
So this bench warrant was ordered before then. Back in the earlier part of May. He's not been in contact with them.
Okay, I will, I did see some kind of a bond violation report, Your Honor. And that's why I assumed it wasn't on today because the warrant had been issued, so.
I'll leave the bench warrant outstanding and then he's having a medical issue. You can send it in a recall and I'll look.
Well, I'll get in touch with him. And we'll figure out what's going on.
All right.
Thank you.
Thank you. Let's call the case. People versus Devasier Hennings.
The original deputy for people.
This will go much smoother. Christina Costantino on behalf of
I do
Mr.
not believe that's true.
Mr. Headings, can you please state your name for the record?
Devasier Henning.
Thank you.
Judge, this is a date and time set for our PCC. We have just recently, as of yesterday, received some additional discovery that has led me to believe that there is some additional outstanding discovery. So given that, we would be asking for an adjournment of the PCC.
We do have a great chief.
I do.
Oh. We are prepared. Yeah.
See, I told you it'd be smoother.
Yeah.
Mr. Kenny's co-defendant, Mr. was actually on the 3 p.m. block with Ms. Barwell. I saw her actually in court a few minutes ago though. So I just wanted to make the court aware, that his co-defendant will be here much later today.
All right. June 5th work for you? Well, I can do the 29th. Will that be better? Because
If we could do the 29th, that would be great.
probable cause conference, May 29th, 2025, 9 a.m. Bond continued.
Thank you very much, Judge. Have a good rest of your, out of your hair.
You're done?
I'm out of your hair.
Really? You're done. Took up 4 hours. Now you're done. All right. Have a great day. Time I don't get back. Court calls the case. People versus Reno Sabe.
Goldstein appearing on behalf of the defendant. Your Honor, the defendant is not present. He can be on Zoom if necessary, but we had already been notified this matter was going to be dismissed prior to today. I believe that Ms. McDuffie has an order for the court.
Well, is that correct? It's going to be dismissed?
That's correct.
No objection.
No, Your Honor.
Case is dismissed. Is he in Zoom? Mr. Sabe, sir, state your name.
Yeah, good morning, Judge Reno Suave.
All right, your case has been dismissed. I'm assuming you don't have any objection to that.
No, sir.
All right. Have a great day, sir. Thank you.
Thank you, Judge. Appreciate it.
Court calls the case, People versus Cedric Johnson.
Morning, Your Honor. Edward Dukas on behalf of Cedric Johnson.
All right. Your name, sir?
Cedric Johnson.
All right.
At this time, we'd like to set this for a preliminary examination
All right, he does have the bond violation.
for the new case.
Well, is there another case coming?
There's another case that he's got
Pardon?
he has a misdemeanor charge that came through from that was the bond violation in this case.
This is the one where he had a double contact.
That's correct, Your Honor. There's a misdemeanor count of DV in 1482.
But that's not considered a violation of this one?
No, it is, Your Honor. He was arraigned on that case on 5/12.
We just did an arraignment last week to get this date. Or was it when was our arraignment?
It was
The arraignment was on Monday this week. And he got this PCC date to go in front of you.
Right, but there's a bond violation, is what I'm indicating.
If the court has it. I mean, I'm in receipt of understanding that there's a new case that I would anticipate being that bond violation. Because he wasn't.
Well, I don't know that. He was arraigned on a
He also failed.
bond violation.
He failed to show up at the exam.
That case is the bond violation.
Okay. Well, what am I gonna do with the bond violation at this point? I mean,
It's difficult to address if he's got a pending case. And
well, at this point, his bond is revoked in any event, so it's gonna be revoked. You want this set for preliminary examination? Why is this one listed before? No.
it was previously,
Set before,
yes, it was an exam that was set. And
that's what I thought.
failed
It was
to-
set before me.
That was on 4/29.
yeah, he did turn himself in last Sunday. He had the mix up of the court.
So
date.
all discovery is complete.
Yes, Your Honor.
People have their witnesses available. My next date is June 3rd.
Who's our best, Your Honor?
Preliminary examination will be set June 3rd, 2025, 9 a.m. That's before me. Thank you.
Thank you.
Thank you.
Court calls the case of the People versus Areli Benzara Vilchis.
Ashley Lonnie for the People.
Good morning, Judge Lawrence H. Margolis, with and on behalf of Ms. Barraza Vilchis. Ashley Areli, please state your name.
Good morning, Judge. Areli Barraza Vilchis.
Okay, what are we doing?
Judge, it's the first plea. I believe we're waiting on some discovery. I'm asked to adjourn it, and I would defer to the prosecutor as to the time she would like.
Your Honor, there is outstanding discovery, specifically the autopsy, as well as the lab results. So that's going to take a little bit of time. I can't say with any definitive
Understood.
facts how long, but it's gonna take at least a few weeks, I would think.
Probable cause conference will be adjourned June 12th,
Maybe people be heard on bond.
2025, 9 a.m. Yes, that's the bond.
Your Honor, could the court inform us how many times the defendant is testing per day? She's on a sober link. I couldn't quite tell if she got a sober link or a scram.
So she had,
I have her on a location tracking. I think I have her on a scram.
Excellent. Thank you, Your Honor. Nothing further.
Bond will continue with its conditions. Thank you.
thank you, Judge.
Court calls case People versus Danielle Landman.
And then on behalf of the people, Your Honor.
Carolyn Foster Tucker on behalf of Danielle Lampman. You state your name. Hi, Danielle Lampman.
Thank you. Yes. All right. Record should reflect we had a bench conference. What are we doing on this case?
Your Honor, we're requesting a preliminary exam,
And all discovery is complete.
to my knowledge.
We'll have the witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Washington. I will also execute an order that defendant, to the extent we can, her mail privileges, her ability to send mail will be restricted. I'm just not sure how that's going to look, but we're going to shut down her potential communication with the alleged victim, in this case, the best way we can. All right. Thank you. Court calls the case, People versus Michael Hill.
Good morning, Your Honor. James Fifelski on behalf of Michael Hill, who unfortunately is not here. I just went out to the hallway to check to see if he was present and did not see him. I've called him a couple of times and wasn't able to leave a voicemail message. So just for the sake of the record, I would ask for one brief adjournment.
He already has a bench worn out.
Okay.
So his failure to appear, I'm just gonna leave the bench worn out.
Is there a bond set on that or just
He has no bond.
no bond? Okay. Thank you, Your Honor.
Court does call the case, People versus Angelica Tower.
And is it on behalf of the people, Your Honor?
For Angelica Towers.
Angelica.
Thank you. All right, what are we doing?
Your Honor, there's some negotiation and I'm asking for an adjournment today. I'm asking for a short adjournment. And I understand that the bond violation,
Pardon?
maybe a bond violation as well.
Yes, violation of her no contact order.
That's correct. I had the understanding, I was contacted by the complaining witness in this case. I was told that he had spoke to the victim advocate, two of them, and he would like to address the court today.
For what reason?
To allow contact.
That is correct. He is here to request contact.
In light of the bond violation? I'm not gonna do it that way. I mean, I have an alleged bond violation. Now I have somebody coming through wanting contact. What I will do, probable cause conference, I will adjourn to May 29th, 2025, 9 a.m. I will also set it for a bond violation hearing at that time. And then I'll hear from the parties. So actually that's, on that day. For probable cause into bond violation here. Bond at this time will continue. Thank you. Court does call the case, People versus Julia Sosinski.
Ashley Lonnie for the people.
James Fifelski on behalf of Ms. Szynski. State your name for the record, please.
Julia Sosinski.
All right, I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of use of heroin, a 1-year misdemeanor. Upon her successful plea to that charge, the felony would be dismissed. There's also the agreement between the parties of no 7411 delay or deferred.
That's correct, Your Honor.
Correct, Your Honor.
Let's have her sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give, the whole truth and nothing but the truth, so help you God.
Yes, I do.
State your name.
Julia Sosinski.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of heroin. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 1483 District Court. You understand that?
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form today, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of April 3rd, 2019, location of US 23 near North Territorial Road, Northfield Township, Washtenaw County, State of Michigan. Did you have heroin in your possession?
Yes, Your Honor.
Did you use it?
Yes, Your Honor.
And did you know what you were using was heroin?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Before satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
June 16th at 9 a.m. for Judge Freshour.
June 16th, 2025, 9 a.m. before Judge Freshour. Bond with its conditions will continue. Thank you.
Thank you very much, Your Honor.
Court calls case People versus Larzell, Washington. Larzell, Washington.
Good morning, Edward Lucas on behalf of Larzell, Washington.
How you doing, Your Honor?
I'm doing great. What's your name?
Larzell in Washington.
Thank you.
Thank you, sir.
Your Honor, we had referred this over to the recovery court. I spoke with them and they indicated that they've in receipt of all the information to do an intake. However, they have not done that interview. That interview could be completed within the week. Like if we could have a 1-week adjournment.
Probable cause conference, May 22nd, 2025, 9 a.m. Bond continued. Court calls case People
Excuse me.
versus Marquise Fab.
Oh, excuse me, sir.
Yeah.
Can I please have a word? With all due respect.
I think Mr. Washington would like to address bond.
Excuse me, miss.
Go ahead.
How you doing, Your Honor? My
I'm
name is
great.
Larzell near Washington. First and foremost, forgive me about my outbreak last time I was here.
Can I have that file?
And thank
Go
you,
ahead.
sir. Thank you, sir. What happened was, I wasn't aware, as my attorney indicated, what day was my probable cause hearing was. Okay, I went back to the magistrate. They said, no, well, we're gonna let Judge Simpson handle it. Then last time I came here, it was a 2-week hold because they didn't do their job. I feel I shouldn't have to be.
Who didn't do their job?
What you say? You gave him a plea.
The recovery court?
Well, I didn't ask for no recovery court, but whatever assessment you gave him, it was 2 weeks. And the honorable judge said, okay, well, I'm not going to change his bond. Now, you still didn't indicate I was looking for a bond. And I wasn't even aware of a drug court. So with all due respect, I do appreciate you, but I did, unfortunately, miss my court date.
Right.
I was.
And then how'd you come into custody?
Oh, I came into custody? What, trying to be a good Samaritan. Some woman was being stalked and they figured out what my name was. And I totally forgot. I really didn't know what court date it was. And I was disciplined for the first And in discipline, well, not necessarily discipline, you allow it to, override until they took care of their own situation, but it's not my fault.
So they who is they?
Would you explain to him?
Well, I think I got to collect more of that story.
Okay, you gave him a piece of paper about assessment along with a plea.
Mhm.
Okay, I get here today, the assessment is not taken care of. Right?
You just want them to speed up the process.
No,
I think we
not
gotta-
them. It's not his fault. He's a judge.
Mhm.
They supposed to be.
Thank you. That's right. Nothing is my fault.
No, yes, it's not.
That's right. I know.
Amen. So I'm saying, I'm just trying to, sir, live my life. I normally work the carnival shows. I have really been disciplined for not being aware of to show up. I'm not dumb enough not to show up again.
Excuse me one moment. Whose phone is that? It's somebody down there's phone. Is hers? Tana's phone? Really? Go ahead, sir.
And I'm not ignorant enough not to show up in front of Judge Simpson courtroom again.
I think he is saying that he would show up to court next time. He's asking for a PR bond.
Yes, I am, sir.
If the court would not provide a PR bond at this time, if the court would allow an interview to take place, if that interview takes place, then the court provide a PR bond.
I never said that. I asked, could you please provide a PR bond? And I will.
I addressed this the last time you were here.
What was it about?
I think they're gonna keep you in.
All right, man, you're fired. God bless you. And thank you, Your Honor.
Why is he fired?
Because he's not speaking up for me. I really don't even know what's going on.
Oh, it would, okay, so did you understand before you make that final decision about firing him? It wouldn't have mattered whether you spoke or he spoke. I was denying your motion. I've already heard it.
Well, I don't know. Why are you denying the motion? And what's so funny?
Because
wow,
because you appeared here, didn't show up, didn't turn yourself in, got picked up, got brought here.
Yes,
that's how we got you back.
And
so I'm not releasing you
right,
now.
the magistrate.
Okay, so
did not release me, and then
that's right.
You didn't release me because
that's right.
Wait for assessment. Am I correct?
And I haven't had the assessment yet.
Exactly. So is it my fault you haven't had the assessment? Is it your fault?
My fault? I thought nothing was my fault.
So whose fault is it?
I don't know.
But it's not mine. You do agree?
No, I don't agree.
The assessment, do I?
I don't know whose fault it is. It hasn't happened. I'm done.
Pretty much. God bless you.
Thank you. Thank you, Ron.
Well, keep talking. Why are you up here at my podium? Why are you at my podium? Why are you at my podium? Next time, Tana, turn your phone up louder when that's going on.
And then it was.
Did I call your case?
Yes, you did. You called, Mr. Babb, Marquise Babb.
Oh, that was so long ago. You're right. You are right, Miss Cannon. And I usually criticize you for not getting up here on time. And I have to give you credit that you're like early.
Got it, Judge.
Court calls the case, people of the state of Michigan versus Babb.
That is done on behalf of the people, Your Honor.
Stephanie Cannon, on behalf of Mr. Babb, who should be appearing by Zoom. Oh, thank God.
Mr. Babb?
Please be there. So what had happened?
Marquise Babb, you need to unmute and turn on your camera. Every week, Cannon. Every week.
I was doing my part today. Your Honor, we're just setting it for a preliminary exam.
What?
We're simply setting it for the preliminary exam.
I gotta have him, I don't know who, I gotta have him here. Oh, you're just gonna call him?
Yep.
Never mind. I'm gonna say something. This is practicing law by janaza. That's what you're doing right now. This is
Great, you got it.
yes, acting really. This is so you. You're like, what? Oh, uh-oh. Mr. Babb?
Yes, sir, Judge.
All right, you got your camera on?
You need the camera as well?
Yes, yes, Mr. Babb.
That is his camera on.
Yes, it's already.
Is that Mr. Babb?
That's Mr. Babb, Your Honor, yes. The good news is he'll be here in person the next time, Your Honor.
I won't be here to witness it. It's going to somebody else. All right. All discovery is complete, Ms. King.
Yes, Your Honor. Discovery is
People
complete.
have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Fresh Hour.
Thank you so much, Your Honor.
Thank you. Bond will continue. Court calls case of the people versus Marvin Sullivan.
Andrew Childers appearing on behalf of you.
James Fifelski appearing on behalf of Mr. Sullivan, who is approaching. State your name for the judge, please.
Marvin Sullivan.
Thank you.
Your Honor, this is a first PCC. I'm asking for an adjournment for discovery and investigation. So I can review discovery with my client, and if I could possibly address bond, I would appreciate it.
Probable cause conference, May 29th, 2025, 9 a.m. I need a screen sheet.
Your Honor, I know you hate it when I do this, but I actually have a trial in Wayne County that day. Could we do the 3 weeks out?
June 5th.
Thank you very much, Your Honor.
2025, 9 a.m. Esteban.
Your Honor, it's my understanding a $10,000 bond has been set in this case. My client has a lot of family in and around Romulus. He would reside with his mother in Romulus if he were bonded out. Has been gainfully employed doing demolition work out in Detroit, has 3 kids, custody of, I think, 2 that are in Michigan. And to my knowledge, I haven't had a chance to verify this, but it did not have any prior convictions involving firearms or assaultive activity. And I believe that while he has another pending case, that case has a PR bond. So I would ask the court to consider a low cash bond.
What's his other pending case?
I'm not sure.
They got up to driving without ops on the person.
Maybe a misdemeanor case.
So he's got another weapon charge.
Apparently so. I don't know anything about it, but it has a PR bond, so.
But that case preceded this one. And then he picks up this one.
I don't know.
Actually, the other case that he has here is the other issue is that the defendant does have an extradition warrant from Mississippi. And we haven't, and I did verify, I spoke with Ms. Burton Harris yesterday about this in our office. We're awaiting the actual governor's warrant from Mississippi, but we have verified that there is a warrant for him out of Mississippi.
But we don't have the governor's warrant yet.
Correct. And so there is a CCW, Mr. Sullivan has a pending CCW charge out 8/27/22. And then the facts of this case I believe fall. So that the older CCW, which is still pending, predated this offense. Mr. Sullivan does have a prior CCW conviction under HIDA, 2012. And obviously this case involved possession of firearm and shooting it in the vicinity of a Washington County Sheriff's deputy who was training canine in the back of the parking lot. It's not charged with, he wasn't charged with shooting at that deputy, but the reason this came to law enforcement's attention was the deputy was training his dog, heard gunshots and saw a car drive off. And our allegation is that if Mr. Sullivan was shooting, basically testing out his new gun that he shouldn't possess in the vicinity of the deputy. I'd ask that bond, frankly, the $10,000 bond.
Bond is
seems
low. Anything else?
Nothing further, Your Honor.
Didn't think so. Bond denied, most of the bond reduction is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Cassandra Gray. Four. Sorry to wake you.
Sorry, I'm busy probably handling her case, so. Your Honor, Assistant Public Defender Jay Bellinger on behalf of Ms. Bohr. Ms. Bohr, can you please state your name for the record?
Cassandra Emborg.
Court has before it a plea form. Is that what we're doing?
Yes, Your Honor, I have an advice right before me.
All right. The plea form indicates that the defendant would be pleading to an added count 3 of operating while intoxicated second offense, the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That's our understanding as well, Your Honor.
That the people's understanding?
Yes, sir.
May I have the defendant sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Cassandra Bohr.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated second offense. Is that correct?
Yes, Your Honor.
All right, that is a misdemeanor, punishable by up to 1 year incarceration, a $500 to $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
You understand that the court could also order community service, any rehabilitative services the court deems necessary, could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You
Yes, Your
understand?
Honor.
All right. Now, understanding all of that, you still wish to plead guilty.
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are a part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's been stated here today to get you the plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
May 27, 2022, at the location of US 12 and Horse Road in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
I had drank beer during the day, ate, and then I went to a bar and I had liquor, a couple drinks at the bar. I hadn't drove at all that day other than returning home that night when I got pulled over.
And Your Honor,
Were you stopped by the police or was there an accident?
I actually hit a ditch with my boyfriend's car and yeah,
So
the
there
police
was
were
an
called to the
accident.
scene. I couldn't get out.
You
of
didn't
it.
do that on purpose, did you?
No, Your Honor.
So there was an accident? Not with
Yes, Your Honor.
beer? All right. Did the police arrive?
Yes.
All right. Were you ultimately arrested?
No, Your Honor. I was taken to the hospital for a blood withdrawal. And then I checked myself.
But
into
you
the
were
hospital.
taken there in a police car in
Well,
the,
yes, Your Honor.
right?
Yes,
So you were arrested.
yes,
You weren't free to leave at that point, correct?
correct.
All right. There was a blood draw.
Yes.
All right. What were the results of that blood draw?
Your Honor, we would stipulate to 0.277.
277? Ma'am, do you have any reason to dispute those blood test results?
No, Your Honor.
Had you previously been convicted of operating while impaired on or about April 18th, 2013 in the 18th District Court and or operating while impaired on or about June 30th, 2014 in the 34th District Court out of Romulus?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3, counts 1 and 2 are dismissed. Pre-sentence investigation and report and screening and assessment is ordered at 14B District Court. Sentencing in this matter will be
July 3rd at 10 a.m. with Judge Washington.
July 3rd, 2025, 10 a.m. before Judge Washington. Bond with its conditions will continue. Thank you.
You're all set, okay?
Court calls the case of the people versus Tania Jackson.
Ashley Lonnie for the people.
Jay Mack, appearing on behalf of Ms. Jackson. I don't know if Ms. Jackson is joining us.
Who do you have?
Burmeister. He's pulling on Jackson right now.
Okay,
He's pulling Jackson right now.
okay, thank you.
Good morning, Your Honor.
Make their appearance.
Yes, Your Honor. Ashley Lonnie for the people.
Hugo J. Mack, appearing on behalf of Ms. Jackson.
Your name, ma'am?
Tania Jackson.
All right, what are we doing?
Your Honor, I've had a brief conversation with the prosecutor. I would ask that you allow both of us to approach the bench or something that I need to inform the court of.
Approach. All right.
Thank you, Your Honor. We would mutually request, myself and the prosecutor, that we.
I need a green sheet prepared. I'll adjourn probable cause to May 22nd,
Yes.
2025, 9 a.m. Bond continued.
I can put that we requested, it doesn't matter.
Court calls the case, people versus Michael Brooks.
I'm seeing this.
Okay.
Public Defender Jay Bellinger on behalf of Mr. Brooks. Oh, I think he's on, yeah.
Michael Brooks,
There he is.
need to unmute and state your name, please.
Can you hear me now?
I can hear you now. State your name.
My name is Mr. Michael Brooks.
Thank you.
And Your Honor, we are just requesting a set for examination at this time. All discovery is complete to the best of my knowledge.
People have their witnesses available the 27th.
I'm sorry, John.
Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Washington.
Thank you, Your Honor.
Bond will continue. Court calls the case, people versus Kyle Burmeister.
And on behalf of the people, Your Honor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Burmeister in case ending in 5078, Your Honor.
James Fifelski appearing on behalf of Mr. Burmeister on the case ending in 5028.
Burmeister, can you please state your name for the record? And Your Honor, we're just requesting a 3-week adjournment for purposes of him going in inpatient. He's just awaiting a bed right now.
That is correct, Your Honor.
Probable cause conference, June 5th, excuse me. 2025, 9 a.m. Bond will continue.
We are,
All right.
Sit up here, not doing anything. Okay, one second. Thank you, Your Honor.
Court does call the case of the people versus Winona Harvey.
Jennifer Douglas for the people.
Harvey.
Morning, Your Honor. Hannah Mack, requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Brian Bowling.
Permission to practice is granted. Good morning.
Thank you, Your Honor.
Right. Ms. Harvey, can you state your name?
No, I can't. I know, you got, my last name is Michelle. Where are you? Where are you?
I met with you in jail yesterday.
Look, if it's gonna skip, okay, yeah, okay.
All right. You're Miss Harvey?
Yeah.
Okay. You're seeking an adjournment?
I am, Your Honor.
No, not you. I'm not Miss Harvey. People don't miss Harvey. I'm Harvey. I'm Harvey like that. People don't miss me, but I'm Harvey.
Okay, maybe she doesn't want to be addressed as a Mrs.
Understood.
I know miss. People don't misses me or nothing. I'm the Harvey.
Sorry about that.
My apologies.
Okay.
Probable cause conference will be adjourned June 5th, 2025. 9 a.m. Bond continue.
We'll be in touch, Harvey, okay?
When?
I'll come
Excuse
visit
me,
you.
what's going on?
We just adjourned your case. Winona, remember we spoke yesterday and you said
Until when?
Which date did you get?
June 5th.
June
Sorry.
5th, you wanna see me?
No, I'm gonna see you before then.
Look, I'm not going back, I can't go back in the conference room, that hurt my back a lot. That room you took me and hurt my back a lot.
Okay, I'm gonna let you talk to your attorney some other place, okay?
Okay, make
Thank
sure.
you. Shut her, please.